Welcome to California in Focus. I'm Cole Lauterbach, managing editor of the Center Square. Joining me today is the Center Square's California reporter, Kenneth Schrupp. We're going to be discussing how a tech group announced this week a lawsuit against California's social media age verification law. Now, this technology group filed an emergency injunction this week to block the new California social media law before it's set to take effect next year. Kenneth broke this story. Kenneth, tell me a little bit more about the premise behind this law in the first place and what the point of it is.
Well, as you can imagine, the point of this law is to supposedly reduce the impact of social media on children, especially with regards to addiction and using the phone during school hours or when you're supposed to be sleeping. However, the steps that the state would take to require this, which involve potentially submitting government ID, determining whether or not individuals are children's parents or not, to make this law actually functional, could lead to some major restrictions on free speech, especially online anonymous free speech on major social media sites. This law, SB 976, requires platforms to get parental consent for minors to use personalized feeds, aka anything with an algorithm, and limits minors' social media use to 1 hour per day unless parents override the restriction.
Now, the lawsuit coming from technology group NetChoice, you had mentioned constitutional breaches here. They filed this against Attorney General Bonta, and they're saying that, one, the unintended consequences of this that were bandied about during the actual debate, and then, the actual in practice law, once it takes effect in January, is going to breach multiple U.S. constitutional amendments, in terms of where, not only the students got rights in the Constitution, but also the parents. What are they alleging before the judge in seeking this injunction?
Well, they're alleging first that you're going to be requiring everyone to prove they're not a child to be able to make full use of some website like Twitter. You'll have to prove that. How? Well, that's up for the California government to decide. And if other states' social media or even online content access requirements are any indication, that could mean maybe having to provide bank documents or government ID to prove you are who you say you are. And this creates, or at least that's what NetChoice says, this would create a very high barrier for people to overcome just to use social media sites and access constitutionally protected speech. For example, if you can only scroll on social media for an hour a day without uploading your ID, you can miss out on essential news in your area. You might miss out on disaster-related content. Remember, in California, we constantly have wildfires, power-related issues, earthquakes. People need to stay on top of what's happening. And even for students, them not being able to access basic online content presents free speech issues in and of itself. Some of the other procedural aspects the law points at are more economic. There is the aspect of how the law creates distinctions between different types of companies that are allowed to send notifications and some aren't. For example, ESPN can send notifications to its users, but YouTube, which runs ESPN shows on it occasionally, might not be able to send you a notification. And so all of these rules are going to create issues for just normal people who want to use social media.
Now, for transparency's sake, NetChoice has members that have vested interest in this, including Google, which owns YouTube, as you mentioned. Meta is Facebook and Instagram. You've got Nextdoor for the boomers wanting to wonder what that loud noise was, Pinterest, and X, which is formerly known as Twitter, which, to your last point, is important because that has become one of the main sources for news, not only in the country, but worldwide. And that lends to the argument, I would think, that you would be losing out on a valuable stream of information by being subject to this barrier. But I think there's another point too, is the ability for people to protect their personal identification under this law, because like you said, they have to submit IDs, and these things are, digitized and stored and placed on servers that we can see from the most recent years, they're susceptible to getting hacked.
Yeah, that's right, Cole. Just earlier this year, we saw the social security number of every American leaked because a third-party background check website left a database wide open. And this data trove was at first sold and then later given away for free. So it really does not seem reasonable to expect that all of these social media companies are going to be able to securely take your information and not tie it to your account. And this leads us, of course, to more fundamental issues as Americans. The right to anonymous speech. The Federalist Papers, many of the founders of our country communicated ideas anonymously that they couldn't otherwise with their name unless they risked their lives. It seems that this rule could end that ability, especially given the amount of data leaks that we've seen from these large data providers.
And also, I think what's important to notice here, too, is that as with many laws in California, because the most classic case is them requiring notifications on otherwise benign seeming products, given to consumers, that there's something in this product or in its packaging that is known by the state of California to cause cancer. And because companies offer their products to people in California and elsewhere, everybody in the country then is faced with these notifications that the state of California deems what you're about to consume cancerous. And this is no different, because if the law applies to people in California, it's likely that if a company like Meta is not wanting to get sued, they're going to probably make everybody adhere to a similar type of law to this, because they don't quite always know where people are based on where they're logging in from. It's not an easy thing to figure out, especially in the age of IP masking.
Right. The jurisdictional impact of this is uncertain. Earlier coverage from us on this did suggest that it could have nationwide implications. I spoke to the lawyers at NetChoice, who seem to say that there's a lot of vagueness about exactly who it would apply to. For example, it clearly does apply to California residents, but does that mean if I go to another state on vacation or work that I still am subject to the requirements? If I'm in, say, Virginia. On the flip side, does that mean people who are visiting California, does that mean they have to be subject to the requirements? It's very unclear, and we could see companies take the broadest possible measure, which is just to make anybody in America or who's an American go ahead and confirm their identification and age.
Kenneth, thanks so much for this story. Thanks for joining us today. Listeners can keep up with this story and more at thecentersquare.com.